That's very sweet. All right, welcome back. Hope everyone had a lovely Passover, a good Easter, happy Ramadan, everything. Very good time of year, I think. Good time of year right now. Um, Reminder, Saturday at what time? 10:30, right? 10:30. We're going to be doing a review session. I will be going over the fall 2020 midterm. I don't know what room number it's in. I don't know the room number. I'll find out. Thank you. 316. I appreciate people know things. Good. 316. Okay, good. I encourage you strongly to take 90 minutes before Saturday and do the exam. If you just show up and say, "Oh, I'm just going to listen, it's going to absorb in," no, that's not how it works, right? I mean, you can do it, right? It's not, it'll happen, but the most effective way is for you to take it on your own, and then as I go along, grade yourself. And then if you have a question, put your hand right up. I will stay as long as you need. I'll be in my office afterwards. You want to come talk to me? But I will be here. Also, there's an admitted student reception on Saturday. You guys ever come to that? When you're thinking of South Texas, the admitted student reception? I like that. Do you enjoy that? I don't know. I think I get a chance to actually talk to people. You like it? I like it at least. And you get a chance to sort of tell people on South Texas. I always enjoy it. It's my favorite things of the year to do. Okay. They're not jaded yet. It's not like orientation where they're like already afraid. They're still hopeful. Um, I want to begin class today by going over the case we studied so far. One of the hard parts of this topic, takings, is that there are so many cases, and you're probably already feeling that they're going in all different directions, right? You think you know something, and then you get another case, and you think you know something, you read another case, right? And so far, we've done 4 cases plus 2 today, so 6 total cases on takings. I want to go through one at a time. Okay. The first case is Hadachek, right? Hadachek. This was the case that involved a prohibition on baking bricks. And the court said, yes, you can do that. Under the police power, you can prohibit nuisances, or what might be called today, because that's the phrase we use in our cases today, right? Harmful or noxious uses can be prohibited. No need to pay compensation. If this is a common law nuisance, you can ban it. If this is some other kind of nuisance which is recognized as common law, you can ban. Okay, that's case number one. Case number two is Penn coal, right? This was the case involving a ban on digging for coal underneath homes, underneath structures, right? The court said, no, you can't do that. Why? Because the regulation went, and this is the actual test from Justice Holmes, too far, right? The regulation went too far. What does that mean? Well, too much of the value of the property was diminished. Now, was it 100% or something less than 100%? I think it's safe to say something less than 100%, right? You still are able to own the land, you could sell it, right? Maybe there are other minerals there you can withdraw, not coal, but this is a pretty big diminution in value. Now, when you see this concept, it goes too far. Does that strike you as a bright line rule? No, the answer is not. This is what you might call a balancing test, right? You'll see these all the time in law school. It's a test with different factors, and you sort of weigh this against this, right? What's the public's interest versus what are the property owner's interest, right? You sort of say, does it go too far? It's not a bright line rule. Okay? With me so far? All right. The next case we studied is Penn Central. Please, for the love of property, don't confuse Penn Coal and Penn Central. You will on the exam. Like I can just see it on my paper in front of me that people confuse them. They're different cases that sound a lot alike, right? Just it's torturing law students for decades. I'm sorry. Penn Central involved the ban on building any air rights above the train station in New York City. Okay. And Penn Central put forward another balancing test, right? And Penn Central says you look at different factors, right? What is the economic impact? What is the character of the taking? My favorite, what are the distinct investment-backed expectations, right? What was your investment? What do you stand to lose if you cannot build this tower? But again, Penn Central is a balancing test. Generally, under Penn Central, the property owner loses. I'm not making this up. There's statistics that study this. It's very rare that the property owner wins under Penn Central. The government almost always wins. So if you are a property owner and the judge says, okay, argue under Penn Central, you're gonna lose. Right? And I think even Lucas didn't even argue who would win under Penn Central. He acknowledged he would have lost under Penn Central, which is an important point because you're gonna lose. So as we say this debate of whether you apply a bright line rule or Penn Central, just know when Justice Stevens says apply Penn Central, he means you're going to lose, right? When Justice Blackmun says apply Penn Central, you're going to lose. When Justice O'Connor says apply Penn Central, it means you're going to lose. Just remember that in the background. They're debating about, oh, is it Penn Central? This, that? No, it means are you going to win or you're going to lose? That's what the case is about. And just keep that in mind. All right, so again, we have the Hadachek case, we have Penn Coal, we have Penn Central. Excuse me. The fourth case we studied is Loretto. Loretto was a case where the city of New York, always New York, right? The city of New York required the installation of certain wires and other equipment on apartment buildings. These cables were used for television signals. Okay. Did the court here follow the Penn Central balancing test? No. No. Here we had what was called a permanent physical occupation. A permanent physical occupation. What does that mean? There's something physically installed in the building that will be there forever. Now, it's not forever, ever, right? But it's forever enough for our purposes. right? When you have some physical item that's occupying your property for an indefinite period of time, permanent, right? That's a taking, okay? But what's important here is that there's no balancing, right? It's a bright line rule. It's a bright line rule that if there is a permanent physical occupation, you have a taking. You don't consider the economic impact. You don't consider what the public's interest might be. You don't consider what are the investment-backed expectations. There's a taking, period, end of sentence. Why does this matter? Because look, the cable is really small, right? How much did it actually impact the property value of the building? Probably zero or close to it. Yet there's still going to be a taking. Meanwhile, with Penn Central, they stood to make millions of dollars with this tower. And it's like, ah, never mind, you can't build it. Enjoy your sunlight, enjoy your air rights. So these cases are sort of at a contrast, right? The most trivial installation of a cable gets you to a taking, but diminishing millions of dollars of air rights, nothing. Okay, yes. It means under current law, there's no end date, right? In theory, at least, the city could repeal the statute tomorrow, but so long as the law remains as it is today, it will remain that way. That makes sense? Good question. All right, so everyone with me about, oh, I misspelled occupation, I'm sorry. Permanent physical occupation. Everyone at least get the four cases we've studied so far. It gets worse today, I promise. Blame Justices Scalia and Stevens. They just don't want to get along in this one. Okay. I want to give you a term, right? Term is categorical or a categorical test. You'll see it different ways. Okay. What is a categorical test? A categorical test is what you might otherwise call a bright line or per se test. In other words, if you meet certain conditions, you necessarily satisfy the test, right? If you meet certain conditions or factors or elements, Lord help us, right? If you meet certain factors or conditions, you satisfy the test. In other words, if you fit within a category, you satisfy the test. That's what's called a categorical test. If you can sort of nuzzle yourself into that category, boom, you got a taking. So Loretto is an example of a categorical test. If there's a permanent physical occupation, boom, categorical take. No balancing, no Penn Central. We just go right to the end. You get your money, get your compensation, right? And think of like, defamation per se or strict liability. And I'm sure there are other examples, right? If you meet those conditions, boom, there's liability, right? You impose the penalty. Now, the concept of a categorical taking is at odds with Penn Central, right? Because didn't Penn Central say there's no bright line? We apply these ad hoc factors, right? So what you see in the two cases today is this sort of struggle between the Penn Central supporters, like Justices Stevens and Blackmun. By the way, Stevens dissented in Penn Central. We won't talk about that anymore. He dissented in that case. But Justice Blackmun on the one side, and then Justice Scalia, who doesn't like Penn Central, on the other side. And they're sort of fighting over when do we apply a Penn Central balancing test and when do we apply a categorical test. Now, again, why does this debate matter? If you apply Penn Central balancing test, the property owner will lose like 97% of the time. He's going to lose. Just take that as a given. But if we apply a categorical test like Loretto, well, then the property owner is going to win 100% of the time. So there's this fight. When do we apply a balancing test which lets property owners lose? And when do we apply a categorical test such that the property owner wins. Right? That's what this fight's about. That's why Lucas went one way, and then Justice O'Connor changed her mind, so Tahoe went the other way. Sort of exaggerating, but not by much. If you ever know a justice trying to keep 5 votes, look how often he quotes a member of his. Justice O'Connor said this, and she's so wise. And Justice O'Connor, it's sycophantish, but Stevens knew what he was doing. He knew he could count to 5 like anyone else. He knew how to keep majority and hold. You see it, okay? All right, everyone with me? Yes, sir.
Is Penn Central really 100% Lutheran?
It's in the 90s, right? I see numbers in this. It's very rare for a property owner to win under Penn Central. For it to happen, it's generally that you have something there that you've been doing for a long time, investing money in it, and the government says stop doing that. The other context where you might win is a flooding case, which is this own category where the government floods your property. But generally, if you have to bring a case under Penn Central, you're going to lose. It's in the 90s. It's very high. Okay. All right. Everyone with me? All right. All right. I want to go back and give this framework that I gave you last week. We're going to be modifying it today. I'm sorry, but I want to just have it on the board so we can just repeat. Okay. So the first step in a takings inquiry, you can ask yourself, is there a permanent physical occupation? Is there permanent physical occupation? If the answer is yes, then under Loretto, you have to pay compensation. Okay? I'm just going to add one other element. We call this a categorical regulatory taking. Categorical regulatory taking. That's all I'm adding, right? Because under Loretto, if you fit this category, this category of permanent physical occupations, it's regulatory taking categorically. There's no, I put this in caps, no balancing. No balancing. We do not do balancing. We do not consider the economic impact. We do not consider what kind of investments you might have made. Straight up, this is a taking categorically. Everyone cool with that? Everyone good? All right, I'm going to come back to this chart in a bit, but let's just keep going. Okay, so now we ask, what if there is not a permanent physical occupation? Excuse me. Again, what if there's not a permanent physical occupation? So far before today, we had 2 branches where we could go with this. One, if there's a harmful or noxious use under Hadachek, there's no compensation. Again, if there's some harmful or noxious use under the Hadachek standard, there's no need to pay compensation. This is police power. That is still good law today. Even Justice Scalia agreed with Hadachek. So that's still good law today. But then we did the other case, right? What if there is no harmful or noxious use? Well, then we have to get to our Penn Central balancing test, right? We do Penn Central balancing, which is the DIBBs and the economic impact, all that good stuff. It means you lose, right? It means you lose. You're gonna lose. But just be careful about that. But you have to at least walk through those 3 elements. So this was the law until about 1992 or so, when we got to Lucas, right? Lucas represented what seemed to be a significant shift in how we do takings cases. Ultimately, it turned out not to be a big deal, right? Because Justice Stevens won 8 years later or 9 years later in Tahoe-Sierra. But for a while, people were like, "Oh my God, this is going to undermine Penn Central," and it didn't. Yes, Liz. Please. If you want to say that Penn Cole and Penn Central are on the same line, you can. I think what Penn Central is trying to do is give teeth to Penn Cole. When does regulation go too far? When it violates those 3 factors. So that's how I would put it. But Penn Cole doesn't really fit anywhere on the map.
Okay.
It again, Holmes didn't really tell us anything. Just as oh, went too far. And in defense of Justice Holmes, I don't think he thought he was making this landmark precedent. It was a fairly minor case. right? About coal mining. I don't think he meant this to be this definitional standard. But when you're a Supreme Court justice and you write an opinion, there's a way of sticking around. It doesn't go anywhere for a while, and people are still reading 100 something years later. Okay, with me so far? All right, we'll come back to this flow chart later in class after we do the cases. All right. Okay, so again, so far the only categorical test we've studied is Loretto. But our first case today, Lucas, would either recognize a new categorical test, if you're Justice Scalia, or if you're Justice Stevens, it invented a new categorical test. We'll discuss both of those perspectives in a moment. All right, let's do the facts. Who am I up to? Does anyone even remember? Caitlin, how long you've been waiting for like a week, haven't you? I'm so sorry. I know that's torturous. All right, do you want to give me the facts, please, and Lucas? Thank you. Okay. Good. Right. Let me put it this way. When he purchased this land, what were his expectations? What did he intend to do with the land? Correct. Good. All right, continue, please.
Came the 1988 Beachfront Management Act.
Good.
And this act was looking to protect, I believe, the beach's dunes.
Correct. Yeah, the sand. Good.
And so
Dunes are piles of sand. I don't know what a dune is. I don't know what that word. It's a mound of sand. Go ahead, please.
And so he was no longer able to build the homes on his property.
Right.
So he takes it to court. He's like, this act is preventing me from building these homes. I think this is a taking.
Good.
Pay me. I can no longer use this property. And the lower court agreed with him.
Good.
And then it went to the Supreme
Court. Let's just, what did the lower court find? Then I'll go into Lexus in a moment. This actually point's very important. What was the finding of the trial court here?
So the trial court found the property to be valueless.
That's the key word. Okay, you're good. Thank you, Caitlin. Very good. All right, so we have Mr. Lucas. If you read the book, there's kind of like this biography event. He's like kind of sort of a odd duck. He was very passionate about this case. He thought the fate of the Republic turned on his case, as people often do. But Mr. Lucas bought these two lots for nearly $1 million. This was in the 80s. So there's a lot of money we're talking about. At the time, there were no restrictions on whether he could build. Now, he didn't actually build right away. Again, there was about a 2-year gap before this law was enacted. So in theory, he could have built. And I think there was some suggestion in the case that he never intended to build. Maybe he wanted to resell it. So in terms of Dibbies and Penn Central, he didn't have any, right? He basically had vacant lots, which he was just letting sit. There's some evidence that he wanted the land to appreciate in value some more. He wanted to wait for it to become more expensive. Maybe. We don't know for sure. So Lucas basically said, he's not going to win it or Penn Central. Everyone knows that. But he makes a different argument, right? He relied on some cases in the 80s, which suggested that when the government deprives your land of all economically viable use, that's the phrase they use, all economically viable use, that's a taking. All right. So again, with Penn Central, the presumption is there's still something you can do with the land, right? The parcel as a whole. You can still look at the train station. But what Lucas contended is, I have no use for this land. It's just sitting there, empty, vacant. I cannot build what I want to build. There's no economically viable use. So he sued the government and he sought compensation. Okay. The trial court found that the land was valueless, that it had no value whatsoever. And this is a position that's contested heavily by the dissenters in this case. So I don't want to just assume that's true, but the trial court found that the land is valueless. Usually, when a trial court makes a finding, you keep the facts unless there's some really serious abuse of discretion. So I guess here the dissenters thought this was completely wrong. Okay. Now, Alexis, let me call on you next, please. The case goes to the Supreme Court of South Carolina. Kind of weird what happens there. Maybe just sort of sketch out what happens at the state Supreme Court, because this makes a big difference to the dissenters.
So they basically said that they use the pin code holding of being harmful,
Good.
noxious
Good.
use. So that it doesn't constitute a taking. It's more so in the police power to regulate the public health.
Excellent. Did the trial court make I'm sorry, did the Supreme Court of the state make a finding of whether the land was valueless?
They disagreed with the trial court of it being valueless, I believe.
Jade?
I don't think so.
They didn't. I saw her nodding. I'm sorry. She was in my vision. So, Jade, so just to clear up, did the state Supreme Court make a finding on whether the land had any value still?
No.
Correct. Why is that important?
It didn't I guess coincide with what the trial court.
So when
Mhm.
as the case came to the Supreme Court, was there actually an appellate finding about the value of the property? No. And this is important. So Justice Souter, who didn't do very much in his time in the court, but he did something here, would have dismissed the case, saying that we don't have a complete record. We don't actually know for sure where the land's value is. Justice Kennedy seemed to agree with that. So this is what you call in Supreme Court lingo a bad vehicle. You ever hear that phrase? Vehicle. When a case goes to the court, it's described as a vehicle. In other words, will this allow the court to decide an important legal question? And this case had a lot of red flags. In other words, you didn't have a clean opinion from the Supreme Court of the state. You didn't have a clean record about the value of the property. You didn't have clean evidence about whether he intended to build. So there were lots of problems. And again, Justice Black, no relation, is just livid. He's like, how on earth are you deciding this case with all these problems, right? If anything, just remand the case to the lower court to look at it again. So putting aside the property issue, there are a lot of sort of procedural issues, right, of why this case may not have been best vehicle. The majority finds that we can get past through it, but Justice Blackmun says they're forcing it to reach this issue.
Like the Supreme Court's so selective on like the cases they take. Why would they even take this one and not like just wait for it?
Yeah, it's a good question. So two answers. One, maybe when they took it, they didn't realize they had all these problems. In other words, the problems may have only become obvious after all the briefing. That's why Justice Souter would have dismissed the writ as improvidently granted. In other words, we took it, my bad, reject it, which the court does from time to time. The second answer is there were not many cases involving such how we put it, such an obvious problem where they said you can never build ever again on this land, right? Most governments were smarter than that. South Carolina wasn't that smart apparently, right? Look at what happened in Tahoe-Sierra. Oh, it's just a 2-year moratorium. Okay, here's another 2 years, right? And here's another 2 years, right? If you're smart, you don't call it permanent. Here they said this is permanent. So maybe the justices sort of looked past the sort of procedural problems because this was a very easy way to sort of distinguish Penn Central. But I don't know. We can ask. I guess Justice Thomas. Everyone else is dead in the majority. Thomas is still here, right? So no, it's true. I mean, maybe their papers. We'll read the papers in some years about why they did what they did. Yeah, the justices keep their papers. Maybe Justice Blackmun has paper on these. I don't know. But the justices, whenever they grant review, they grant certiorari, they have a conference where they talk about it. And Justice Blackmun would always take notes about why they granted, why they didn't. So maybe there's something to be learned there. I don't know. Yeah, the papers are sometimes helpful, sometimes not. I've gone through them myself. There's sometimes there's some funny insights and jokes, and they'd often pass notes to each other on the bench, like baseball scores and things. There's oh, here we go. Justice Blackmun would rate advocates. He would grade them on a scale of A through F. Get rid of this one. So there's one case, I want to make sure I get this one right, where Justice Ruth Bader Ginsburg was arguing a case. I think he gave her, yeah, I just checked it. He gave her a C minus when Justice Ginsburg was arguing one of the cases. And I hope I'm not making this up. I'm sure I'm not. I'm pretty sure I'm right. Who did he call? Okay, I'm not gonna say it, but I remember he made a fairly sexist comment at someone, and I can't verify it, so I don't want to say it. But he gave Ginsburg a C minus. So he always would rate the advocates. We have all his papers. So he was a weird guy, Justice Blackmun. Yeah, Clayton. Ain't that something, huh? Yeah, yeah. Fun fact: I only realized this over the weekend. This case, Lucas was decided the same day as Casey, and it just occurred to me the entire purpose of this case is the land economically viable? Viability was the line. And what was the standard in Casey? Viability. I was like, oh my God, it just hit me. And if you actually listen to the oral arguments, Justice Blackmun actually says in the arguments, viability is a good term for medicine, but not for law. Irony is not dead. I'll give you another one. He actually had a T-shirt. I'm not joking you. So he wrote Roe v. Wade, right? With a picture that said Roe v. Wade, and one person was rowing a boat, another person was wading in the water, and he would wear this T-shirt of Roe v. Wade. He was a weird guy. I mean, later on in his career, he basically lost his clerks, took over. There's a memo to one of his law clerks, which basically said, the opinion looks fine. Can I check the citations? He was basically checking citations at certain point. He wasn't actually reading the opinions. He was just basically letting his clerks run the show. What was the famous line? Shall tinker with the machinery of death no longer. One of his clerks wrote that line. So you'll kill a missile with a mouse, whatever that the line was. That was a law clerk. That was not him. Okay, I'm done Blackmun bashing. Okay. I think you're next, actually.
I have a question.
Okay, ask your question. I'll call on you.
So law clerks for the Supreme Court actually like write opinions, and then he was just checking the site.
Basically, towards the end, he wasn't actually doing anything of substance.
That's crazy.
Yeah.
That's so
Oh no, that's scary. Having a 25-year-old in charge of the Supreme Court is very scary.
cool.
What do I know? All right, I think you're next. All right, so the South Carolina Supreme Court didn't actually decide the issue about whether the land was valueless. This case goes to the Supreme Court, right, Max? How does Justice Scalia approach this case? Did you read it?
Yeah.
Okay.
He approached it with can he balance the public interest and
Scalia,
see I'm confusing with justice.
the majority. How did the majority approach this case?
I'm not sure.
Elsie? Okay, so just you're right, Kelsey. So we have this little flow chart here, this beautiful flow chart, which will now become irrelevant in a moment. Where does these facts fit on our flow chart here, according to Justice Scalia? Is it 1, 2A, 2B, 2? I mean, where does this case fit in our flow chart? So are you telling me there's a 2C? Yeah, there's a 2C, my friends. I'm sorry. I think I told you last week the flow chart will get worse, and I was trying to be as honest as I could. So we have a 2C, right? Sarah, and actually, to be precise, I'm going to call the harmful noxious use 2C. I'm going to make a B over here because it'll make more sense. So we had these two, right? If it's a harmful or noxious use, we would have had a check. And if there's no harmful or noxious use, we go down to Penn Central balancing. But we wedge in something else between A and C. Sarah, what's the new test that we wedge in between A and C? What's this new standard?
So it involves where the regulation denies the economic beneficial.
How much of the economic value?
Um,
How much of the value? This is the important word.
it says
Some of it?
all.
All. All right. Yes, ma'am. So if a regulation deprives all economically viable use, okay, and again, the key word here is all. We're talking 100%. If some regulation deprives 100% of the economic value, you have to pay compensation. Okay, and as Kelsey said a moment ago, this Lucas test is categorical. It's a categorical test, right? There is no balancing, all caps, no balancing. If you fit in this category of a 100% economic value wipe out, all of your values wiped out, 100%, there's no balancing required. Right? We will get in a few minutes if in fact his property value was wiped out. I want to just give you the test first. Right? So the test Scalia says is if 100% of the value is wiped out, you don't balance. Okay. But wait a minute. How does this third one make sense now? I'm going to modify C. So you apply potential if there's no harmful noxious use and it does not deprive all economically viable use. Okay. I know. I'm sorry, Duke. I'm sorry, sir. And I'm gonna modify it again in a minute. I'm building up to it. This is just you gotta trust the process, as they say. What's that?
So I'm waiting.
Okay, you can wait. That's fine.
Or I write and have to cross
Okay,
out.
so again, under category 2, right? Again, if there's not a permanent physical occupation, we first ask ourselves, is there, that's a typo, should be harmful or noxious use? Is there harmful or noxious use? The answer is yes. Under how to check, there's no compensation. Okay. Okay. 2B is actually if there's no harmful or noxious use. Sorry, I'm messing up your outlines. And it deprives all economically viable use, you pay compensation. Under the Lucas categorical test, there's no balancing. Okay. But if there's no harmful noxious use and it does not deprive all of economically viable use, less than 100%, then we go to penitential balancing. You're going to hate me after the next case. This gets even uglier. But I want to just walk you through this. Okay. So what Justice Scalia is saying is, we are not disturbing Hadachek. Hadachek remains in the books, right? Hadachek remains. If there's a noxious use or harmful use, okay, then there's no compensations required. Okay. What happens if there's no harmful noxious use? We then look at how much the value is being diminished. If there's no harmful noxious use and there's 100% diminution in value, 100%, under Lucas, there's a taking, there's no balancing. If there's no harmful noxious use and you're at less than 100%, penitential balancing. I'll just put the numbers in if it makes it even easier for you. Be or not to be is right. Again, if there's no harmful noxious use and a 100% diminution in value, compensation, categorical, straight up. If there's no harmful noxious use and there's less than 100% diminution in value, then you go to penitential. I know you hate this so much. I know, I'm sorry. It gets worse in a few minutes. And let's just be clear. Under 2A, government wins. Under 2B, government loses. And under 2C, government wins. Depending which line you fall into, you apply different tests. And depending which test you apply, the government either wins or loses. How are we doing? All right, so again, let's go back up to I'm going to spend several minutes on this, I promise. You guys see the entire thing? Duke, you can see everything? Okay, good. I know that Whoever designed a desk that literally blocks the screen didn't. These classrooms make no sense, right? There's a desk in front of the monitor. So first we ask, is there permanent physical occupation? That's easy. If there's something with a hammer and nail, you're done. You don't have to go through step 2. You're done. But if there's not a permanent physical occupation, you have to then consider the option. Is there harmful, noxious use under HADA check? There's no compensation. You're free. You're good. What if there's no harmful use and there's deprivation at 100% of the value of the property, 100% of the economic value? You then have a categorical taking under the Lucas standard. Must provide compensation. No balancing. Does not matter what the public interest is. Doesn't matter if the beaches will erode and the land will be fall into the ocean. None of that matters. Hurricanes, whatever. Get a life raft, right? Does not matter. But under the third one, if it's even 99.999% diminution of value, then we do not use a categorical rule. We go to Penn Central balancing. Max. Yes.
It's okay.
It's all good? Okay. Everyone with me so far? Jordan?
For the permanent physical occupation, isn't there also like a distinction we need to make if it's like something like a smoke alarm or something to like?
You really want to make this more complicated? I mean, look. Yeah. Yes. The court distinguished smoke alarms as being within the police power. Not very persuasively. So I would not clutter your chart with that. But I will clutter your chart with one more thing. Sorry, I told you it's gonna get worse. According to Justice Scalia, what is a harmful, noxious use? Can the government just declare anything a harmful, noxious use? No. Patty? No. What limitation does Justice Scalia place on this category of harmful or noxious uses? Excuse me.
This where he starts talking about
What's Scalia looking to?
if it's preventing harm or if it's benefiting.
It's sort of, but what body of law is Justice Scalia looking to when we're defining harmful, noxious uses? And when was this nuisance law developed? Recently?
No, like
What do we call the old stuff? Who said it? Common law. So what Justice Scalia says, and this is actually probably the most important part of Lucas, is he narrows what is a common law nuisance. In other words, the legislature can't just say, you know what, we think that building by the beach is bad, that's noxious. Scalia says there has to be some sort of objective standard, and he would turn to the common law. And the reasoning here, I can explain to you, right? Scalia says that when Lucas purchased these lots, he understood that there are certain restrictions on his title. What are those restrictions? What are common law nuisances? In other words, when you buy property, you can't make a nuisance, right? What Scalia says is that limitation is inherent in the title. It's inherent in the title. You might say it's a background principle. That's the word Scalia uses, right? A background principle is the common law doctrine of nuisance under state law. It's not permissible for the legislature to say, okay, beaches, erosion, we have this new problem. Let's just designate building a house a nuisance. You can't do that. So in your notes, I'm just going to add CL for common law, right? Put in for each of those 3 lines. Under the Lucas test, and by the way, Tahoe did not overrule this. This is still good law. Whenever you talk about a noxious or harmful use, it has to be based on some common law standard. In other words, not modern stuff. We got to go old stuff. Now, yeah, exactly. And the legislature cannot simply decree newly, as Patty said a moment ago, different types of noxious uses. So in a way, and I think Stevens makes this point in his dissent, the law is frozen, right? The sorts of land uses that can be prohibited are frozen in time, but was done long ago. New problems new situations that arise cannot be addressed by the government. And by the way, what case does Justice Stevens cite when he talks about these frozen in time? Lochner. It's not in your book, is it? No, it's not in your book. I read the case last night. Yeah, I went back and reread. They actually took this case out of the book for like 2 editions. They brought it back, so I had to reread the entire thing just to. I'm sorry. That's why your case run was so late last night. I was up till midnight finishing it. But he cites Lochner, right? Justice Stevens cites Lochner, and he says the majority is returning to the era of Lochner. I swear, it's like Marcia Brady, Marcia, right? Everything is Lochner with these people, right? And under the Lochner doctrine, the courts do not allow changes in response to changes in circumstances, right? You're frozen in time what kind of regulations you can impose based on common law, and you can't do new stuff. And Justice Stevens vigorously opposed this common law standard. But Scalia said it's unfair to impose new restrictions on people that they could have not expected when they purchased the property, right? Their expectations were one thing, and the government can't impose, they can't newly decree different kinds of land use restrictions. Whew. All right. So I know this chart looks different than it looked like 20 minutes ago. I'm sorry. And if you're taking notes by hand, my sympathies, thoughts and prayers, right? But get this one down cold because it will change another 10 minutes when you do Tahoe-Sierra. I'm sorry. I'm sorry. You have all your pens lined up. Okay. Okay. I'm going to pause here. Questions, my beloved students. Does this make sense? No, this is not easy. I was actually at a law school yesterday. I was in WashU in St. Louis. I saw another popular professor. Oh, I'm teaching tomorrow. Lucas and Tahoe-Sierra. You teach that? She just skips it. It's too complicated, right? She doesn't. She basically cuts to the end. She gets to the end of the case. She doesn't do the intermediary cases. My students have to struggle for it. All right, everyone get what the majority did here. I'll walk through the actual case itself in a moment. Everyone get the framework. Max, is that a hand now?
Yeah, so like you just can't impose land use restrictions that you didn't anticipate when you buy the land.
The government can't decree new harmful, noxious uses. Right? In other words, if the government wants to use its police power to regulate land, they must identify some common law standard that permitted them to do this. If they decree some new standard, then we're either in a categorical test if there's 100% diminution, or the balancing test of Penn Central if it's less than 100%. But unfortunately, and someone always asks me, Professor Blackman, Josh, what the hell do I do for the exam? And the answer is this. And it's going to be this plus Tahoe-Sierra, and also this plus a few other cases. So these questions are I'm sorry. Don't blame me. Blame them. They're the 9 up there. They're there above us. Don't blame me. I'm just a messenger. Don't shoot me. What?
think they're.
Oh, they do. Yeah, he's at it, Steve. All right. That's actually a hard question. Is a yacht lodging or transportation? No vehicles in the park, right? Okay. Questions on this framework? We actually walk through the case. All right. Now let me walk through the case and sort of hopefully this makes a little bit more sense. The Supreme Court before Lucas had never actually applied this 100% diminution value test. They'd sort of said it in 1 or 2 cases. And again, that's the problem. When you say something in a Supreme Court opinion, it's there and you can't unsay it. And what Justice Scalia did was he basically latched onto this language from a few of the cases from the 80s. And so I said, we have this test. And he basically created a new categorical test. So how many categorical tests we have now? We have Loretto, which is a permanent physical occupation categorical test. And we have Lucas, which is the 100% diminution in value categorical test. We have 2 categorical tests. Now with the categorical test, we don't care what the public interest is, right? If you have this complete diminution in value, you must provide compensation. Okay. Now, Scalia thought that these cases with 100% diminution will be rare, and he's probably right about that. Very few cases actually followed Lucas. We'll see this later. But at least for those cases like South Carolina, where they're sort of brazen enough, say you can never build anything here, you're likely going to lose. Now, Justice Stevens wrote a dissent. And he says, "Wait a minute, this can't be right. Let me get this straight. If there's 100% diminution, you get value, full value. If there's a 95% diminution under Penn Central, you're going to lose. You get 0. How can this make sense, right? How can it make sense that the 100% standard makes such a big difference for the value?" And Scalia responds basically, sometimes there's an all or nothing balance in property law. What Scalia would really want to respond is Penn Central's wrong, right? And he can't though because he needs to keep 5 votes, right? This is getting more into the con law, but sometimes when Scalia writes an opinion, you can feel he's pulling his punches, right? Because he needs to keep O'Connor. He lost Kennedy, he had White, but he needs to keep O'Connor, so he pulled his punches. Right? I just feel like Scalia is like handcuffed in his opinion because he wanted to just destroy Stevens, right? Fire an actual missile at him, but he couldn't. So when you get to this part of like this doesn't make sense, Justice O'Connor did not want to diminish Penn Central. She liked that case. In fact, she reaffirmed Penn Central in the Palazzolo case. We'll read about it some years later. So Scalia couldn't repudiate Penn Central. He would have overruled if he had the votes. Rehnquist had dissented in Penn Central, 4 decades earlier, 2 decades earlier at that time. Okay. Scalia also reaffirmed Hadachek. There's another case which was in the reading called Mugler versus Kansas, Mugler, Mugler versus Kansas, 1887. This was a progressive era case where where Kansas banned the manufacture of alcohol. Right, you couldn't make alcohol, and they wrote a takings claim. And the court held there was no requirement to pay compensation. Now, just pause there for a minute, right? They couldn't make drinking alcohol, but maybe they could make, I don't know, apple cider, a non-alcoholic beverage, right? Was there 100% diminution in value there? No. Think of Hadachek, right? You couldn't bake the brick there, but you could still extract the coal from there. Was this 100% diminution in value? Scalia says no. Then we get to Penn coal. And this is why Liv asked me at Penn coal before. Don't put it in your chart. It doesn't fit anywhere, right? Then we get to Penn coal. They couldn't extract the coal from the land. Was this 100% diminution in value? No, they still had the value of the land. They could have sold it. They could have done other things to the land. So at least with Mugler, Hadachek, and Penn coal, when you have a nuisance involved, you still have some value in the land. So you can reaffirm Hadachek, Mugler, and Penn coal without blowing this chart up. Okay. Then we get to the question over whether there was a harmful noxious use here. The lawyer for South Carolina said this is a serious ecological disaster, right? Unless we protect these beaches, the land will be destroyed. If there's a hurricane that blows through, there will not be enough soil to absorb all the water. We run off, houses will flow into the ocean. It'll be really bad. And what the court basically says is that's nice, but that's a modern problem, not one that was inherent in the title when it was purchased by Mr. Lucas. So you can't rely on the Hadachek Mugler line of cases. You can't simply declare some use as noxious. Right? When Lucas bought his land, he knew what the rules were, and you can't change those midstream. Think back to the Moon Township case, the adult bookstore case, right, with amortization. It's very often the case that the government will change rules and to give you a period to wind down, right? But at least here, under the federal constitution, you can't impose new noxious use standards and try to get around the requirement to pay compensation. Okay. Then we get to, I think, the fact-bound question, right? Was the land actually deprived of all economically viable use? And just focus on the standard for a minute. Why are we limited to economically viable use, right? And Stevens and Blackman's make this a point in their dissents. You can do non-economic uses. You can go camping. You can go fishing. You can, go swimming in the water, right? There are lots of uses that do not require money changing hands. So even on the facts that the trial court said there's 100% diminution in value, that depends if you say value is only economic, that is resale value, or can economic be recreation, for example. So the judges vigorously disagree on this point, right? What is the relevant metric to calculate value? The Justice Souter and also Justice Kennedy said we can't rely on the trial court at all for this. Okay, but Scalia held 5. He didn't do it often, but he held 5 here, especially that term. That was also was that Levy Weissman was also decided that day. It was, if memory serves. Was it June 29th, 1992? Levy Weissman was 4 days earlier. Another huge defeat for Scalia on the Establishment Clause. This was the case involving the prayer during high school graduation. Did you get? Oh, you didn't learn this yet. About whether a rabbi could give a speech, a barely religious speech during high school graduation, and Scalia lost that case. So this is a very bad term for Scalia because he lost Casey. He was unhappy this year. At least he held 5 here. Okay, everyone okay with the majority opinion? I want to go through the dissents and concurrences now. All right, Justice Kennedy concurred only in the judgment, and he did not actually agree with the words Scalia wrote. Jetsky called a concurrence to me actually agree with the majority. He concurred in the judgment only. All he would have done was send this case back to the South Carolina Supreme Court. And what's interesting is that Justice Kennedy thought there may be a temporary taking, right? The law was changed around 1990 such that Lucas could have gotten a permit. But Kennedy said for at least a couple years, he couldn't build anything. And maybe during that period, there was some temporary taking. That wouldn't get you the full value of the property, but maybe something less than that. But he wouldn't decide it because it's an incomplete record. Justice Souter, again, would have, the acronym is DIG, D-I-G. You might hear this, you dig the case. Dismiss as improvidently granted. Dismiss as improvidently granted. In other words, whoopsie, our mistake, we shouldn't have taken the case. This happens maybe once or twice a year where the Supreme Court grants a case and realizes, oh, this is way too hard, right? Or this is not worth it, or the facts here are not clean, or there's disputes in the record. And we're not going to make a landmark ruling where there's disputes in a record. So they just say, dismissed, never mind, whoopsies. There's a sort of a joke, but there's a law clerk that recommends a grant, and then they dig the case, it looks bad in the law clerk. In other words, the clerk said, take this case, this is a good case to recommend. Oh, do you know this works? I'm sorry, take a step back. Usually when there's a petition for certiorari filed, the justices all consider it. But 7 or maybe 8 of the justices have what's called the cert pool, where they sort of all work together. And one law clerk is assigned to write a memo, and they recommend either grant the case or deny the case. Yeah. A cert pool, C-E-R-T, certiorari. Cert is short for certiorari, a cert pool. So it's basically a pool memo. So one law clerk from all the 7 justices, maybe 8, not sure, puts in a memo saying grant or deny, and then the justices vote on it. So it's often said that if a clerk recommends a grant and it turns out there was a problem with the case, a vehicle problem, they dig it, it's bad for the clerk. It's not bad. These guys, do you know what the bonus is for a SCOTUS clerk? It's like $500,000 now. It's ridiculous. It's a signing bonus. It's like 400,000. It's obscene. The amount, if you clerk in the court, you get your payday. Yeah. Because of a big law firm, they just and the funny part is you can't even practice for the Supreme Court for like 2 years. Right? There's a 2-year bar, but it's considered so valuable to have SCOTUS clerks in your firm that they just like bring a dump truck of cash and just drop on their lawn. I mean, I'm exaggerating, but it's a lot of money. When I was in law school, it was $250. Now I think it's closer to $400,000 signing bonus. Yeah, that's on top of a salary that's probably close to 2. I mean, just your first year out of clerking, it's just it's like Willy Wonka, like it's the golden ticket. You just cash that in forever. You're not Gus's blue flying away, right? You're gonna cash in. You're like Willy, right? You're Charlie. You get the golden bar. Sorry, didn't want to go there. But anyway, so but Souter of Dig the Case, DIG. Um, Blackman and Stevens were very upset. Again, this was Blackman's, I think, second to last term. He had just written this long missive in Casey that the judge who replaces me will have to answer questions about abortion. Remember this one in Casey? And it was Ginsburg, as it was. But he was just very upset because he had dissented in Loretto and he dissented here as well. But Justice Blackman thought this was an easy case under the Mugler line of cases. Under Hadachek, this was a elimination of a nuisance. Okay. Yes, sir.
Why is he relying on Mugler? That seems like that was not the Fifth Amendment was not important.
Such a good question. I was waiting for someone to ask me that. Yeah. So you probably cite in common law the incorporation doctrine. And it's a messy doctrine, right? We can study it today sort of in the hindsight, but throughout the 1800s and 1900s, there was no single answer about which provisions the Bill of Rights would limit to states. Now, if you read Penn Central and Justice Stevens' opinion, Tahoe-Sierra, he says, the takings clause was incorporated in a case called Chicago and Burlington Railroad versus Quincy, 1898, plus or minus a couple of years, right? No, didn't. If you actually read Chicago and Burlington, takings clause is not mentioned. It was a due process case. So there's no clear case on which the due process clause was incorporated. But going back to Mugler, which was 1887 or 8 plus or minus a few years, what the court said is we don't have to pay any compensation in the abstract, right? There's no violation of due process. It was a due process case, not a takings case. But by the time you get to the 1980s, 1990s, no one cares about that anymore. It's sort of water under the bridge. And frankly, Justice Blackman had this one line in his opinion. We was talking about the nuisance. He says, I'm getting in trouble for this one. He says, we shouldn't care what dead judges think. Right? That was in your book, right? No? Let me make sure I get this one right. I read the entire opinion, so I can't remember what was in your excerpt or not. But Justice Blackman was trying to say, why are we venerating the common law? In other words, why do we care so much what all these common law judges live about nuisance, right? Why can't modern lawmakers define a nuisance? Okay, then you have it. Good. And then he says, this is it. There's nothing magical in the reasoning of judges long dead. There's nothing magical in the reasoning of judges long dead. Yes, Dobbs. All right, let's move on. No, I mean, his lack of just, I'm sorry, I'm not a Blackman fan. It comes through. But he really hated history. He hated any sort of standard that could sort of ground judges in the past. He just hated it very much. And sense like that sort of come back to bite me. At least I think. All right. What else from the Blackman and Stevens systems I want to talk about? I do think, though, they have a fair point about the fishing and camping, right? If you actually take the phrase all economically viable use, there are things you could do. You could drive an RV there. Actually, Thompson drives an RV there, maybe, right? There are things that you can do on the land short of building a structure. All right. Okay, so everyone with me. After Lucas, it looked like there was this other path where you might actually get to a categorical taking. Okay. But little did we know that as Lucas was being decided, there was a dispute going on at Lake Tahoe. And this dispute took 18 years to reach the Supreme Court. Everyone understand that, right? The dispute began in the 80s, and the court decided in 2002. So we're talking like 18 years. Actually, did it begin in 1982 or 1983? I mean, this 1981. So I mean, this case took almost 2 decades to get to the Supreme Court, from start to finish. The developers in Lake Tahoe were smarter than the developers in South Carolina, right? They didn't impose a flat-out ban. They imposed what they called a temporary moratorium. Okay, so let's move on to this. Everyone good with the first case? As it took an hour. I know that case took an hour as long. Second case is much shorter, much easier. Anyone ever been to Lake Tahoe? Yeah, Duke, you been there? Is it beautiful as they say? What's this water? Just in your own words, describe the water. Make a big deal about this blue water.
Wow. Just a different color one. We used to see in green.
Mhm.
For the water. I think it's more because of the snow, the clear. And there's not, maybe there's not as much vegetation because the temperatures will kill the algae.
Oh, is that right?
I'm guessing.
Okay. You know what? You sound like you know what you're talking about, and I'm gonna just go with that one. It's funny. Like yesterday, as I was reading this case in the plane, the lady next to me had a "Keep Tahoe" blue bumper sticker on her luggage. Like, okay, that's kind of funny. I dread people looking at my monitors like, "Oh, you're a law professor. What do you teach?" I'm like, "Oh God, it's never good." I always say property. It's like, "Oh," and they always ask questions, and it's like change the topic, and you're stuck next to them, and you should pretend to go to sleep or something, and then that you should get rid of. It's true. I don't want to give legal advice in the plane. I'm stuck. I'm trapped. I put headphones in. It never works. Doesn't matter. They just keep talking to you. Okay, who am I up to? Daisy, you next? All right, Daisy, you want to give me the facts, please? And this is the name of the case, a mouthful. Tahoe-Sierra Preservation Council versus Tahoe Regional Planning Agency, please.
So property owners in the Lake Tahoe area were prohibited from initiating development to property, so there's too much, in order to get a handle of the development.
Okay, let me stop there, right? Why did the government impose what they call it, words moratorium, plurals, moratoria? Daisy, why did the government impose a moratorium on construction in these coastal areas by the water?
To preserve Lake Tahoe.
Was it a permanent ban on building? What was the purpose of this moratorium?
That's a temporary
Good. And what were they supposed to do during this temporary period?
plan.
Yeah, very good. Good. Thank you. That's right. The purpose of the moratorium was to sort of get a handle on the situation, right? Starting in the 1960s, there was a lot of development. Was it The Godfather Part Two? They have a Lake Tahoe property. I'm making that up. Godfather. Yeah, yeah. In Godfather Part Two, I think the Corleones have a property on Lake Tahoe. But starting in the 60s, there was a lot of development there. And I'm going to mess this up, so just bear with me. When you have a lot of development, you have more concrete, and there's less soil to absorb rain. So as a result, you have what's called runoff, where the water runs down the concrete, runs on the asphalt into the lake. And all this additional water that was pouring into Lake Tahoe would have changed the composition. It would have affected the clarity of the water. It would have made it not this pristine blue, but this sort of green. And there's a footnote in the opinion that says it would have changed the water forever, or at least for 700 years. So is that if not forever, at least for 700 years, which is a very long time. I guess in the long run, we're all dead. It's just as Thomas would say. But it's actually Keynes, but Thomas quotes that. But they say we need to put a pause to define a strategy for environmentally sound growth, right? We need to maintain the status quo, we need to study, and we need to figure out what's going on. Okay, so the first moratorium went from August of 1981 until August of 1983, 2 years. Maria, excuse me. What happened after the 2-year moratorium? Were they ready to roll? Did they figure out their game plan? Did they figure out their strategy?
Yeah.
No. What happened next?
They weren't able to develop the strategy, so they wanted to have a second.
How long was the next one going to last for?
It was gonna last August 19. It's gonna be another 13.
Oh, not 32 months total. Daisy? About 8 months, yeah. It was from August of 83. I'm sorry, August of 83 until April of 84. Another 8 months. Right? Now, they call these temporary moratorium, but they never actually said when these moratorium would end. Because in theory, at least, they could have added a third, a fourth, a fifth, and sixth. There was a lot of discussion. I went back actually and listened to the oral argument. By the way, do you know who argued this case on behalf of the government? John Roberts. Yeah, he did. He was a very good advocate. I wish he had stayed in that role, but he was very good. And it's funny because he clerked for Rehnquist, and Rehnquist is grilling him because Rehnquist voted on the other side. But that's how these things go. Roberts argued the case. It did very well. Now, if you ask the owners of the property, they seem to suggest that this was sort of like, they didn't say it, but like this is sort of bad faith. They didn't really need all this time. They were just trying to stop construction. But at least as John Roberts told us in the record, there's no evidence of bad faith, right? The government agency was moving as quickly as they could, right? It took time to figure out a plan, a strategy of how to limit construction on this pristine area. All right, about 2 months after the second moratorium concluded, the Preservation Council filed suit. Now it's called the Preservation Council, but really they want to build, so it's sort of a weird name for the organization, right? They want to preserve their their property value, right? they call themselves the Preservation Council who wants to build property, right? So they're adverse to the government here, and they wanted to build one-family homes. Now, let's see, Paolo, let me ask you a question. You're a lawyer for the homeowners in Tahoe, and you're in 2002. What's like the leading precedent that you want to rely on to make this case work? What's like the best precedent for you to rely on? No. No, they lose. They lose big league, right? What precedent do they want to rely on here? Why do they want to rely on the Lucas standard? Yes, exactly right. Right. If you're the lawyer for the homeowners, you say, Lucas, right? Categorical taking, please, God, give me money, right? Penn Central, stay far away. We don't want any of that balancing stuff. We want categorical. And if you look at the arguments in this case, like the word Lucas is like in every sentence. Like, well, under Lucas, like that's the test they want. And they make the argument that they were deprived of all economically viable use of their land for the period of 32 months. Now, whether it's 32 months or 6 years, Rehnquist, I don't really care about that, but it's some period of time, right? It's a couple of years, right? Were they deprived of all their economic use for a couple of years? Now, the trial court followed Lucas and said, aha, categorical approach. There's a taking, pay compensation. And I think the trial court faithfully applied Lucas, right? Again, if you're a trial court judge and you have these facts, Lucas didn't really care how long the deprivation lasted for. In fact, how long could Lucas not build for? 2 years. How long could Tahoe not build for? About 3 years. So at least on the numbers, the Tahoe one seems worse than the one in South Carolina. But the Ninth Circuit reversed. And the Ninth Circuit found over several dissents that the regulation had only a temporary impact on the properties, on the plaintiff's value. Okay. After 18 years, the case reaches the Supreme Court. Justice Stevens now has the majority. Why? Byron White was replaced by Stephen Breyer, and Sandra O'Connor changed her mind. She switched sides. O'Connor was with the majority in Lucas, and now the majority in Tahoe-Sierra. And again, I made this point earlier. You know that because Justice Stevens keeps saying, Justice O'Connor said this, and Justice O'Connor said this, right? She was the swing vote at the time, and Stevens knew how to keep a majority together. During the 90s, it was often said that if you could put Justice O'Connor's face on the cover of your brief, you would, right? That's how important her vote was, right? Just then it was after O'Connor was Kennedy, and then it was Roberts, and now it's basically Kavanaugh, right? But there's always been someone that's of course sort of swings around, and it was Justice O'Connor for much of the 90s. Ivan, why did Justice Stevens not think the Lucas test resolved this case? He went a lot of explanation of why Lucas is not the right test. Why is Lucas not the right test here, according to Justice Stevens? Oh, you said it. Look at my magical chart here. Did I say anything about permanent? Is that anywhere in Lucas? Where'd that come from?
Well, they stated that it was in the Tahoe case. It was only temporary. That we're not.
You got it. You're exactly right. Justice Stevens, shall we say, reinterpreted Lucas. Right. What Justice Stevens said is Lucas concerned deprivation of all viable use that is permanent. Permanent. Right? A permanent deprivation of all economic value. This case, Tahoe, is not permanent. It's temporary. Okay, you will see the distinction. Now, I encourage you, go back and read your notes from 7 minutes ago. Justice Scalia, and you can tell me if I'm wrong, does not discuss whether the taking is permanent or temporary. Justice Kennedy does in his concurrence, right? Kennedy says it was temporary, but Scalia doesn't. Again, Lucas could not build for 2 years, and it didn't matter. He got $1 million, full compensation for his property. But now Justice Stevens said there was actually a limitation on Lucas. That's temporary. Yeah, I saw a hand somewhere. Now, why does Justice Stevens focus on the temporary nature? What cases he cite? Penn Central. What does he say? You can't just focus on the period of the moratorium. You must look at the parcel as a whole. He says that. You must look at the parcel as a whole. Justice Brandeis is still laughing 100 years later. Again, that's what I told you. Brandeis was in dissent, but he got the last laugh on this topic.
So the justice said it's like temporary moratorium, right?
That's
So-
what. Yep.
So then, like, I guess, like, at the end, they were kind of right, because in Penn Central, they ended up selling the air rights for, what, like $1 billion, you said?
Yep.
So I guess he was right.
Who was right?
The justice saying it was
What
temporary.
justice? Stevens?
Steven.
Yeah. What else? Oh, there's another hand. All right, again, I want to focus on this point. Okay. Justice Stevens says you cannot just focus on the physical aspects of the property. Property also has what he calls a temporal dimension. Think of Back to the Future thing, right? A temporal dimension, right? You can plot this in a graph, I'm sure. I'm not going to. If the taking is only for a temporary period of time, you don't get the Lucas. To get the Lucas, there must be a permanent deprivation of property. And in fairness, in South Carolina, the statute said you can't build ever, right? So that was there. Scalia didn't focus on that point, but that wasn't the facts of South Carolina of the Coastal Commission. But in the Tahoe case, the government was smart. It said, oh, this is just temporary. We'll just call it temporary. And in fact, if you read the Chief Justice's dissent, he's like, look, government's not stupid. They'll just say everything's temporary. They'll never have to pay compensation. And that's exactly what happened. Justice Stevens managed to basically overrule Lucas without overruling it. Social precedent, right? He basically read Lucas so narrowly that it almost will never apply, because any competent government official will say, aha, we're doing what Tahoe did. We're just making this temporary. During the oral arguments, Rehnquist asked John Roberts, what if it was a 10-year moratorium? He's like, well, that probably goes too far. He actually said that, Roberts, bless his heart. And they said, what about a 30-year moratorium? Well, I think 30 years is probably overtaking, right? So yeah, there's some line. But at least 32 months, whatever it happens to be in this case, did not go far enough. And then Roberts said, well, if it goes too far, then we go to Penn Central, and that might be too much. That's always the answer. The answer is always Penn Central. That's the answer to everything. Alex. Who? Which case are you talking about? I don't know that they actually got a permit, but there's no longer a moratorium. Right. One of the crazy parts is, this was in the opinion, I think it was edited of your book, to build this area took years, like years and years and years to get a permit. So one of the dissenters said, it's not unusual to wait 2 or 3 years anyway to get a permit. What's the big deal? Right? In other words, it takes so long to get a permit, 2 years is like nothing. Someone left. Yeah. Right. In other words, building here is so hard. Stop complaining about 3 years. That's like nothing. Really, that's the cost of doing business in Lake Tahoe. And these are $1 million properties, right? These people are not suffering. It's not like you have nowhere to live. No, these are vacation homes, right? They can go somewhere else. Yeah. It's like nothing. Basically, 3 years is nothing at all. It's a drop in the bucket. Okay. So I need to revise your chart. I'm sorry. I'm sincerely sorry. So I want to go back to 2B, where it says deprives all economically viable use, I want you to add the word permanent. Permanently deprive. Permanently deprive. After the Tahoe-Sierra case, right? I'm going to just write Tahoe-Sierra here. After Tahoe-Sierra, in order to get into this categorical test, there must be a permanent deprivation of property. Permanent. And let me tell you something. Permanent, no government ever calls it permanent anymore. They say it's temporary. Oh, just we're studying, we're taking our time, we're making a plan, we're doing strategy, right? And there's a temporary moratorium. As long as you avoid calling it permanent, you don't get to the categorical test. You go down to our good friend Penn Central. So the entire purpose of Tahoe-Sierra was to basically wipe out the second category. And there's a note about this in the book, I think, that in the years following Lucas, very few courts actually applied it. And in the years following Tahoe-Sierra, almost never is Lucas relevant. It's not going to be the defining test. The defining test is now going to be, again, Penn Central. So no matter how far we get from the 70s, Penn Central is still the test. Until we get to the Roberts Court, then we'll think about the detour, right? But at least in the 90s and 2000s, Penn Central remains the test. You're taking a picture? It's online. Okay. I remember I was a freshman in college. I was old. This was 2002. I actually brought a little digital camera to the board. I was taking pictures of the screen. They were writing with their hands. I couldn't type it all. But resolution wasn't very good. Rooms were dark, so it didn't even work. I had this really old web camera. It was terrible. Maybe 1 megapixel. Dreadful. What? That even exists? I know, right? I'm so old. Trust me, Casey, I promise you, one day you'll be my age. It'll happen. And you'll say something like, "Oh my God, you're so." When I started teaching here, it was 11 years ago. I was basically not too far removed, but you stay the same age. I get older, so we're part of this job. It's true. Trust me, it happens. I'm actually showing my kids what like a video cassette looks like. Just you know what VHS is? You know what that is? If you've seen one, good. Still have some. Good. All right. So everyone understand why I put the word permanent here, right? And that's an important checkpoint. That's what Tahoe-Sierra adds. Okay. All right. So again, that's the majority opinion, right? Stevens does not overrule Lucas. He doesn't have to, but he puts, we might call it a gloss on Lucas, such that the deprivation must be permanent. And so long as the government says this is just temporary, they can avoid having to pay just compensation, which is what they will always do. They won't, and they don't need to call it permanent. They'll say, oh, well, we'll make a permitting process. It takes 15 years to build anything. That's the permitting process. 25 years of permitting process. It's not permanent. Just you have to apply for permits for 25 years. That sounds pretty permanent, right? Chief Justice Rehnquist dissented in this case. And he says this is just misreading Lucas. Lucas had a prohibition that lasted 2 years, which was somehow permanent. But in this case, you had 32 months or maybe 6 years, which was temporary, right? It doesn't even hold up on its own. And Rehnquist says nothing prevents the government from imposing new temporary prohibitions one after the other after the other. And then Justice Thomas said, my favorite quotes, in the long run, we are all dead. That's a quote from John Maynard Keynes, if you know the famous economist. Okay. Questions on Lucas? All right, I want to go back up to my list at the top of the document and sort of just add to it. Excuse me. All right, so we have how to check, which is a harmful noxious use test. We have Penn Cole, which is when a regulation goes too far. We have Penn Central balancing with our distinct investment-backed expectations. We have Loretto, which is our categorical test. I'll just add the word categorical here so we have our complete record. Then we have Lucas, right? Lucas involved a 100% diminution in economic value, and there's a categorical test. But I'll say Lucas as modified by Tahoe It has to be a 100% permanent diminution in economic value. Otherwise, Penn Central, right? And that was the key move that Justice Stevens was a very smart justice. You know, during World War II, he was a code breaker, right? He did encryption in the Pacific during World War II. I mean, like genius level stuff, right? To pull it off. He clerked in the Supreme Court for Justice Rutledge. Really smart guy. Um, his his family owned one of the biggest hotels in Chicago. It's the Drake Hotel, one of the big hotels in Chicago. And he claims that he was at the baseball game where Babe Ruth called the home run at Wrigley Field. He claims it. No proof he's there. A lot of people claim they were there, but he claims he was a kid. He was at the game. Really smart guy. But Stevens did this better than almost anyone else, where he would write an opinion saying, "Oh, we're being very modest, what we're doing here," and they basically overruled the precedent. They basically overruled Lucas. They limited Lucas to basically a nullity, such the opinion no longer had any juice. And again, Justice O'Connor went along with it, and that's why he had the votes. Yes, Alexis.
Are there any cases where there's no common law harmful, noxious, and less than 100% diminution of value that would still be a taking?
Okay, let me repeat what you said. Make sure I understood it. So you're asking. Let's go back to our chart. Okay. So what you're. I'm sorry. I don't want to block your picture. I'll get out of the way. I'm going to scroll now. I'm sorry. Hope you got your shot. So I think what Alexa is asking is, if you're on 2C, can you win? Rare. This is, I think, someone asked this question before. The only way you win under 2C, I think, is if you were doing something for a long time, you'd invested money in it, and the government suddenly said you need to stop what you're doing. Maybe. But the takings law is designed for the government to win. Now, we'll do a case in 2 or 3 classes called Cedar Point Nursery, which sort of upends everything. But at least for this period of time, it's different. It's a hard topic to teach because it changes. I mean, common law must be very hard to teach this year. I'm actually grateful I'm not teaching it because no, I'm serious. I actually don't want to teach common law next year either. I'll take a break from it. We have that perk. Not really. We can ask, but there's no guarantee they honor a request. But it's a hard topic to teach when the answer is things are changing. I mean, imagine teaching common law in the 60s or criminal procedure in the 60s. Like every year, okay, we got this thing called Miranda. Let's do this now, right? We have this thing called Gideon. Let's do this, right? There's always these new things that came around on short notice. Okay, let me walk through this one more time, and I'll let you go home. So the easy one, right, is if I give you facts involving a permanent physical occupation, that is a something drilled into the wall. If I give you that, consider yourself lucky because you can stop. But if there's not a permanent physical occupation, you need to consider a couple things. Is there harmful noxious use at common law? CL, common law. If there is, under Hadachek, Mugler, you can prohibit it. Now, what happens if there's no harmful noxious use? You ask yourself, how much of the economic value is being deprived? And is that deprivation permanent? That's the key thing that Tahoe-Sierra adds. Is the deprivation, excuse me, permanent? And if the answer is yes, then you get a categorical test under the Lucas standard. If the answer is no, you go back to our good friend, Penn Central balancing test. Max?
Is like the percentage of economic use something you would give us or something we would have to like do in our own analysis?
The second one.
Okay.
Yeah, no, it's not that easy. All right. Other questions? All right, I've turned on the exit poll, and I'll be in the office if you want to come talk. But thank you so much, and I'll see you all on Thursday. Thank you.